Hello,
I'm in.
everybody, and welcome to our virtual info session. I just ask you to please mute yourself. We are still admitting participants, and it would be really much appreciated if you can make sure that you're muted. So welcome. My name is Oksana Bilobran, and I am Legal Programs and Policy Manager at the Seattle Office of Immigrant and Refugee Affairs. We really appreciate you coming to this important info session. We are very honored to partner with Northwest Immigrants' Rights Project to bring this session to you today and hope it's helpful and beneficial to you. I'm going to say a few words about what this event is going to be. The idea of this training came from the many requests we started getting and questions from over the last couple of months and weeks from service providers, including nonprofit organizations, community-based organizations that work with Okay, sorry, turns out I was muted. So I was saying that the idea of this meeting came from the
Oh no, you're muted again.
I think maybe when we mute all, I get muted. So we can't use that feature to mute everybody. Can you please just mute yourself? Otherwise, our speakers will be muted. Just to let you know, this training info session is going to be recorded. So hopefully it's okay with all of you. But I do keep getting muted. I'll give it another second or so. Okay, apologies. Okay. So as I was saying, we were getting many questions from service organizations like yours who are providing services, social services, legal, medical, youth programs, event planning for communities that also included immigrants and refugees. And they were concerned amidst all the news and rhetoric. So they reached out to us, and so we decided to bring all of you together here and dedicate 2 hours of our time to go over the following things. Today, me and my co-presenters are going to focus on the three main things. One is a high-level update on the most recent policy changes and what they might mean for the immigrant communities, specifically in Seattle and Washington. Also, we will explain to what extent Washington state and city laws and policies can and cannot protect immigrants in our area. And we will cover some best practices for working with immigrant communities this year. For example, when ICE or other immigration enforcement agencies come to your office. What this session is not going to cover is in-depth issues related to immigration law. For example, requirements, timelines, legal challenges, and funding for immigration-related programs and services. That topic is much more broad, and we're just not able to cover all of that in 2 hours. Also, this is not a Know Your Rights session for impacted community members. We know many of them are being hosted across our communities, but we will talk about some of the constitutional rights that all of us have, including the right to remain free of unreasonable searches and seizures, and the right to document ICE arrests or raids. So we will talk about what to do if, in case ICE shows up at your organization office, or if you see something happening in a public area. So today we will have 2 hours and planning to dedicate at least 30 minutes for your questions and answers. We still ask you to remain muted during the session, and if you have any questions, then please put them in the chat. After each presenter is done with a portion, we will pause, and my coworker Annie is going to go through your questions and voice them to our presenters. So please don't unmute yourself to ask those questions, but rather put them in the chat. Also, as I said, we're recording this session and we'll make it available on the City of Seattle OIRA website. So please check back in a couple of days. It should be there. And lastly, I just want to say we understand that immigration has been front and center of political discussions and can be a sensitive topic. So we really request that if you have any comment regarding government role in welcoming and assisting immigrants or anything of that sort, then please be respectful when you're expressing your comments and opinions in the chat. With that, I am happy to present to you and introduce to you my two co-presenters today, both from the Northwest Immigrants' Rights Project, and that's Malu Chavez, Executive Director of NERP, and also Henry Huang, Directing Attorney at NERP. With that, I'm passing the microphone on to Malu to talk about some of the recent policy changes. Thank you.
Thank you, Oksana. Thank you, everyone. It's great to see so many of you. I know that there's been a lot happening these past 8 days, and I want to acknowledge that we have a strong partnership, a strong state that is challenging many of these attacks against our communities. And I want to thank you all for being here and also for getting the information. I hope that we are able to share as much as we know. A lot of it is day by day. My colleagues at Northwest Immigrant Rights Project and I are in alert about things that are happening. Sometimes we hear them through the news, sometimes we get direct communication. So there's a lot of uncertainty. We definitely have, yeah, can you hear me now? Thank you. We have definitely been feeling overwhelmed, and as you can imagine, our client communities are even more and I'm sorry, I keep getting muted, but I think I should be fine now. Can you hear me okay? All right. And so just some background, I want to first start off with a little update on
You're muted again.
Oh, thank you. And I want to introduce just quickly for those of you who may not be familiar with Northwest Immigrant Rights Project. We are a nonprofit organization offering free legal immigration services across the state. We have 4 offices in Granger, Tacoma, Seattle, and Wenatchee. And we take immigration cases for people with low or no income. We represent people in individual cases, but we also engage in systems change, including legislative advocacy and impact litigation lawsuits against the government to enforce the rights of our immigrant communities. So our mission is to advance and protect the rights of immigrants, and we do this through our legal services work, our systems change, and our community education. And I want to give that background because all of this for us as an organization, we know that our work is needed. We know that we're here to continue serving the community, but we're also advocates, and we're also impacted in many ways. Our work is impacted. Just today, you may have learned that there was a notice to pause federal funding programs, grants related to federal funding. And that includes funding that NERP receives. And so I wanted to start with that because while our communities are impacted, our work is also impacted. We know that there is a stop or a stopping disbursement effective 5 p.m. Eastern time. But what that means is that we also have, as I mentioned earlier, we also have strong partnerships And there are already challenges, there are already lawsuits being filed. We hope for the challenge to take effect, and maybe this doesn't end up impacting, but the reality is that a lot of our funding may be at risk, federal funding. And there are so many things to update on. So I focused on a few, and then of course, feel free to add questions to the chat, and I'm happy to answer them in the chat or as we wait till the very end. The other thing that I wanted to briefly touch on is while there are so many executive orders that I'll discuss in a few minutes, there are also attacks in the potential legislation. We saw that last week with the introduction and voting of the Laken Riley Act. This is a legislation that was voted both in the House and Congress, both in House and Senate. This is a bill that is awaiting the president's signature, and it will dramatically increase who gets impacted in terms of immigration process. People who may be charged or arrested or convicted of a crime, including specific crimes that in our work we consider petty crimes like theft, shoplifting. But then there were additional amendments that added other crimes that people could be found to be mandatorily subject to mandatory detention. And what that means is that someone who is eventually, if the bill is signed, we have to wait to see when it becomes in effect and the level of impact. But if someone were to be subject to this new change, it would create mandatory detention for people that are very specific, right? And so there's a lot of waiting because we need to see the final language, but that is something that we are keeping track of, working with our congressional legislators.
Thank you for calling Arts and Culture. This is.
Thank you. And so that's that. And I wanted to mention that first because that is one strategy for this whole agenda of mass deportation. So we are seeing it through executive orders, we're seeing it through proposed legislation, we're seeing it through narrative and rhetoric, also actions, and I'll go into the actions next. The mass deportation executive order that's called the Protecting the American People from Invasion. It's a very, very broad order that essentially revokes enforcement priorities that were in the last federal administration that focused on enforcement specifically targeting people who were deemed to be national security threats. And it was very limited, right? Certain crimes included or convictions were included, but it was very narrow. Now, with this new executive order, that's no longer the case. This particular order, the Protecting the American People from Invasion, also calls for border crossing prosecution. It also targets nonprofit organizations, and there's also a lot of different ways that this executive order impacts both our communities, but also our work. Then there was an executive order on birthright citizenship. As you all know, Washington State was one of the first lawsuits that were filed, and it is being litigated nationwide. Northwest Immigrant Rights Project has also filed a lawsuit, and I wanted to give an update that we were asked to join the Washington State's lawsuit, and we will be appearing with our plaintiffs, our clients. We filed this lawsuit on behalf of 3 clients. We will be appearing in court this next week on Thursday, and at that day, the court will decide whether to extend its order halting the executive order of ending rights. And we know that as the judge ordered, this was blatantly unconstitutional. It also is contradicting the 14th Amendment. And there's so many different issues with this. It also creates a second-class citizenship status for people. So there's a lot of different, many things wrong with this executive order, but as you know, it is being challenged. Next thing I want to focus on is around the DACA decision in the Fifth Circuit. You know that the deferred action for childhood arrivals is for people who came or entered the country when they were 16 years old or younger. In 2012, it protected so many individuals who, at no fault of their own, were present in the U.S., and many of them were students, and eventually received protection through this program called DACA, Deferred Action for Childhood Arrival. In 2017, there were many challenges against it. It went all the way to the Supreme Court, came back down. Now at the Fifth Circuit, even before that, there was a rule issued essentially codifying DACA. But the Fifth Circuit's decision on the 17th, interesting enough, was the Friday before the new administration came to be. And this ruling upheld the decision that DACA is unlawful, but it limited the decision to Texas. So what that means is people will, it strikes down parts of the DACA program that applies only to people in Texas. But it also upheld part of DACA that allows federal officials to classify DACA recipients as people of low priority for deportation and not remove them. So the Fifth Circuit decided that that this needed to be preserved, that people with DACA, existing recipients of DACA, are protected from deportation. So that's DACA. People in current status, DACA status, can continue to renew their applications, but others are not to do initial DACA applications. So clients with their DACA renewals, that we share that information and that we support our community in order to renew that protection. And then next, we were asked to discuss what's happening with the temporary protected status. As you know, TPS, right before the current federal administration took office, the former administration, the Biden administration, extended TPS for several countries. And these are El Salvador, Nicaragua, Haiti, Ukraine, Venezuela, and Sudan. This is good. All of these were extended to 2026, sometime between February, September, and October. And so our communities who are protected under TPS at least have that protection till then. Of course, our understanding is that any temporary status will likely not happen. And so I wanted to talk a little bit about, next, I wanted to talk about the suspension of refugee admissions program, the USRAP, as many of you know. This was announced also the very first week. What it does is it suspends the entry of refugee people who had already been approved, regardless of whether they were approved or at what stage they were in their case. And it was paused for 90 days, but we believe that this will be likely indefinitely. And so we also understand that there are some case-by-case exceptions, but we don't know yet what that information would look like. And so for people who want to file a new application, at least we know that that's not going to be possible. And so the question becomes, does the suspension impact the Afghan special immigrant visa cases? And no, it does not, but other actions are being impacted, are impacting as SIV applicants, the special immigrant visa applicants, which is a program, an immigrant visa program, rather than a refugee resettlement program. But people who are not yet in the country are still able to consular process, meaning they still go to their interviews to be able to get that admission. And so we understand that the Department of State, which is the agency that consulates are under, should continue to adjudicate these applications. And there are so many other updates related to our refugee community, community as well. But I want to switch now to the protected areas directive. So as you know, you may have heard, on January 20th, the Trump administration rescinded the policy that protected certain areas from immigration enforcement. And while we don't have guidance yet as to what that looks like, we know that it will follow a different rule that has been introduced that gives the Immigration and Customs Enforcement and the Customs and Border Protection agencies, so under the Department of Homeland Security, that gives them authority to take enforcement actions for expedited removal of certain community members, so non-citizens, to what's called the statutory maximum. And what that means is it includes people who have not been continuously present in the US for 2 years. So again, we are still expecting guidance regarding what that means. However, there is a memo that has been issued entitled Guidance Regarding How to Exercise Enforcement Discretion. And what that means is it lists who will be targeted for expedited removal. And again, it includes people who fall under this 2 years of not being continuously present in the US. But it also includes some of our community members who have been paroled and either and because this policy of being paroled has been terminated, we know that there's going to be a lot of our communities that are targeted. There was also an ICE arrest memo, and I know my colleague Henry will talk more about the protected areas, and we'll likely talk about this memo. Henry, let me know if you're not. But I'll skip over to public charge. As you remember, public charge is an analysis that comes into play for admission purposes, so admitting someone to receive immigration benefits. So it applies for someone seeking a green card, for example, applying for a family visa petition, an immigrant visa. It also applies for certain citizens who leave, so lawful permanent residents who leave the country, and upon being admitted, coming back to the US, they may be subject to something called public charge analysis. But mostly we see this around family petitions. And this is an analysis. It takes into account all different factors that someone who's applying to be a permanent resident is subjected to. So their age, their ability to work, for example, their health, and the possibility that they may be relying on government assistance in the future. And so for all of the family petitions, there's something called an application for affidavit of support that the US citizen or lawful permanent resident family member, the petitioner, has to submit, saying that in the event that the beneficiary, the person applying for this benefit, were to seek services, that they become liable, right? In terms of paying that back. And so all of this in the past, in 2017, we knew that public charge was something that the first Trump administration was trying to change. Eventually, it did not, it went back to what it used to be, which is you just have to not be relying on government funding to exist, right? Certain specific benefits, not all benefits. It's very important that our community members know that if they're eligible for benefits, that they should continue pursuing those access to those benefits. But we will likely see something come back. But the idea is not to create further misinformation or further fear. We have to see what they come up with. One thing related to public charge, which is interesting, every time that someone submits an application for a green card, they also have to submit an application for a medical examination, a report of their medical examination. And the COVID vaccine became a required factor in order to receive immigrant lawful status. That's no longer the case. And so this administration now waives that requirement. There are other things that we are keeping track of. I know that there are questions around the parole programs, and I'll try to add them in the chat. I'm conscious of time, and I want to make sure that we are able to cover all the information we have. But I'll end with that while this is a lot, and our communities in particular are feeling impacted and are being impacted, we know that the goal for mass deportation includes mass detention. It's very important that we walk alongside our communities, and that we be as loud as we can, that we call our congressional representatives when things are like today, the funding is at risk, when legislation is being voted against our communities. But for T and U visas, I see a chat question. Nothing has changed yet. From what I understand, we do think that, for example, U visas have a bona fide determination ahead of receiving a U visa. We think that that might go away. There's also potential concern that work authorizations that were issued now at 5 years or 4 years will go back to being 1 year for some categories. So there's a lot of unknown, a lot to be seen, but we will keep everyone up to date. We are updating our resources page. One thing that Henry will mention is we now have an advisory specific to nonprofit organizations and social services providers on what to do if ICE were to show up in their building or facility. There's so much information, but I do ask that you stay in contact with us, that you sign up for our social media or website and receive newsletters from us to be informed. Correct information is the way we are able to support our community, by sharing correct information, because I think that part of the federal administration strategy is to create chaos and to share that anti-immigrant rhetoric and create fear in our community. So thank you for being here, and I will pass it along. Thanks. Thanks, Susanna.
Thank you, Malu. I'm gonna bring up a couple more questions that I think are important. There's a question here, what about those that are in the middle of asylum process? So asylum seekers that have a pending asylum application. Can you address what all these policy changes might mean for them?
Thank you. Yes, so we know that everyone who was able to submit an application is protected. That is pending status. So that should not be a worry as much as people who weren't able to submit their application and are within those 2 years of entry. So yeah, that should not be an issue. And we'll learn more as things change. And I see a question on what providers can do if ICE shows up at our clinic. Yes, my colleague Henry will discuss more on that, and I'll also share that advisory in the chat.
Thank you so much to everybody for your patience. We understand there are a lot of tech issues with sound not being very clear. Answering some of your questions in the chat. There were no slides for this part of the presentation, but there will be for other two. In terms of cheat sheet about all the policy changes, I'll defer to NERP about producing them, but I also know how rapidly everything changes with litigation, but we will share a lot more resources right now in the chat. So please do monitor the chat. We will paste some documents there as well in a second.
And I'll do the same thing. Thank you.
Any other questions that we have missed from the chat?
There's quite a few questions. So one question, advice for anyone who has been granted, I'm assuming asylum, but granted a status but doesn't have access to their documents. What would be advice for that?
Yes. So it depends on what situation that may be. It is case by case basis why they don't have access to their documents. I think the best thing will be to, if they worked with an attorney, to communicate with the attorney. If they've been granted some sort of status, it's important that they know what status that is. And there are ways to be able to get those documents, even if they need to resubmit, for example, a work authorization or a green card replacement card. There are ways to get those, but understanding what status they have, connecting with a legal services provider, yeah, I'll leave it at that.
Thank you. Just allow me a second to share my screen. Hope that works for you all.
And I'll start responding to questions in the chat as well. Thanks.
Okay. Okay, I'm going to talk briefly about some local which means Washington State and City of Seattle laws in place to protect immigrants. Looks like my sharing screen isn't working.
You're muted, Oksana. But we
One
can
of
see your
the
presentation.
Okay, great. So one of the important things to understand about immigration is that it is considered a federal matter. So what it means is that federal government has authority to enforce immigration law, and local government is not required to do that. So it is a federal government responsibility and not, for example, state or city or local law enforcement. Local law enforcement entanglement with federal immigration enforcement often just diverts resources and also blurs accountability when both federal and local law enforcement is on the site conducting raids, for example. That could present a number of legal challenges. So in order for a local jurisdiction to cooperate with federal government, they need to enter in what is known as Section 287G agreement. And such agreements exist in many other states in the country and cities, but they are not in place in Washington state and are forbidden under current Washington state laws. And I'll talk about that in a second. So just to emphasize, currently Seattle has pledged to be a welcoming city. There is no legal definition of what it means to be a welcoming or sanctuary jurisdiction, but in reality, it means that we're not cooperating with federal immigration enforcement and also don't allow them to interfere in the way we conduct our law enforcement in the state. So it is based on some constitutional and other concerns that those decisions are made on the city and the state level. When the decision to become a welcoming or sanctuary state or a city is made, usually lawmakers consider that there might be concerns about violating Fourth Amendment against unlawful searches and detention of people. There might be targeting based on race or ethnicity, which would violate Equal Protection Clause of the Constitution. And also there might be a denial of due process based on immigration process. So all of these are considered to be serious enough for our state and the city to consider and pass welcoming laws and policies. So we also understand that cooperating with federal law enforcement, immigration law enforcement, erodes trust in the community, and then community members are afraid to report crimes to officers and be witnesses in criminal investigations. And therefore, in order to preserve such trust, our local jurisdictions choose to be welcoming. It is not a violation of law, again, because though local jurisdictions can cooperate with federal authorities, they are not required to do so. I'm going to highlight a couple of the local policies in place, specifically in Seattle. We have what's known a Don't Ask policy that's been on the books from 2003, so for over 20 years. And that policy prohibits city employees from inquiring about immigration status of anybody, with certain small exceptions. Also, the city resolution ensures that city provides services equally to all residents, regardless of their immigration status. Seattle Police Department has a policy not to enforce immigration law, not to use resources to enforce immigration law. Also, you might have seen in the media that just recently the mayor of Seattle issued a mayoral directive just a couple of weeks ago that requires departments of City of Seattle to review all of its policies and practices and materials to make sure they are aligned with applicable federal and local immigration laws, and requested that all requests for information that come from ICE or other federal agencies be directed to the mayor's office for review. I also want to highlight two important statewide laws. One of them is Keep Washington Working that was passed in 2019. Keep Washington Working Act prohibits law enforcement in Washington state from inquiring about immigration and citizenship status. Also bars sharing non-public personally identifiable information with federal immigration authorities and forbids detaining individuals only on the basis of determining immigration status, and disallows contracts allowing state or local agencies to detain individuals for civil immigration violations only. So it's a really important state law. If you have not had the chance to educate yourself and your staff on it, I highly encourage you to do so. Also in 2020, Washington State Legislature passed a Courts Open to All Act that restricts courts officials from collecting or sharing immigration information unless it's tied to a criminal case, and prohibits civil arrests at or near court facilities. Keep Washington Working Act required Attorney General of Washington State to develop model policies in order to implement requirements set in the Keep Washington Working Act. And those model policies have been developed and published on the Attorney General website. And I cannot stress this enough. I highly encourage you, and will post these links to the chat in a second, because these model policies could be applicable to the organizations that you work at and services that you provide. So the Washington Working Act requires local law enforcement agencies to adopt these model policies, or if they don't do that, then explain to the Washington Attorney General why they are not adopting these policies and why they're adopting something similar. So you can go on the Washington Attorney General website and check if your if your police department in your jurisdiction have submitted their policies, if they adopted or not. Also, model policies were developed for public schools, for shelters, and for health organizations that provide healthcare services. And so in addition to these organizations that are required to have policies on the books, there are also organizations that are just encouraged to do that. And even if your organization is not squarely a shelter, but provides some sort of housing services, you can, for example, go to these model policies and best practices for shelters, look at what's applicable to you and adopt it for your own organization. Again, I can't stress it highly enough how useful this resource is, and encourage you to all look into it. Okay, did we have any questions about local laws and policies? I see the question if I will share the links. Yes, just in a second when I'm done presenting, I will share these links.
Hi, Oksana. There's a couple questions in the chat. Does SPD's policy prevent collaboration between ICE and local law enforcement?
I cannot state it affirmatively because I have not seen those policies, but they would be required under the Keep Washington Working laws to not cooperate with ICE and not enter in into those agreements that would allow for such cooperation. So if they were to cooperate with ICE, that would be a violation of Keep Washington Working Act.
A question. Some of my colleagues or team were not able to come into the meeting, but is there going to be a recording so we can like share that with them of this meeting?
Yes, there will be a recording and we will post it on our website. And for any other questions, please use your chat option here, because we have 1,000 participants. We're doing all the questions through the chat. Apologies.
Thank you.
Mm-hmm.
The chat is not available. Yeah, the chat says it's unavailable.
Okay, for those of you for whom chat is unavailable, it's okay to raise your hand. I see, or I don't see the full name because the window is so small, but last name Sako.
Can you hear me?
Yes, Rachel.
Hi, I work as a victim advocate, and King County has shared in the past that T and U visa inquiries are considered exculpatory in a criminal case. I'm curious if how to like move forward with that when we're not supposed to like the don't ask kind of policies, if that is something we should ask to be litigated with an attorney, or if you have any insight onto how we should handle that, because it's considered exculpatory in a criminal case. I hope that makes sense.
I'm not sure I'm qualified to answer that question. Malu, is that something that you would be able to answer?
And I'm sorry I missed the question.
Oh, I work with victims of crime, and we have been expected to share any inquiries about T and U visas because they're considered exculpatory in a criminal case from the victim's end. I'm just curious if you have any guidance on that moving forward.
We do have some guidance. I will find it, and if you could share your name in the chat, I'm happy to follow up directly. But
thank you so
Henry,
much.
I see you. Did you want to say something, Henry? No? Okay, thank you. Yeah, just add your name to the chat. Thanks so much.
Okay, thank you. I'll be going through the chat and see if I missed any questions and answering them in the chat. In the meanwhile, Henry Huang, directing attorney at NERP, to talk about best practices for working with immigrants. Henry, feel free to share your screen for the slides.
Yeah, can you hear me? And I'm trying to share it right now. I'm not sure if it's showing up.
I'm sorry, but mine says the chat's not available because it's such a large meeting.
Okay, so then let's just keep your questions. This is our last part of the presentation. We'll open it up for questions at the end. I really appreciate everybody's understanding. But yes, Henry, we can see your slides.
Okay, great. And yeah, apologies everyone for some of the technical difficulties. I think it's just a massive response here. My name is Henry Huang. I'm a directing attorney with the Northwest Immigrant Rights Project. I had no idea that there would be 1,000 people here. I would have worn something nicer. But I do want to thank everybody for being here. I also want to thank Oksana and the city of Seattle for organizing this. You know, this is really encouraging to see so many organizations that are interested in learning how to sort of continue your services to the community and sort of in the face of all this chaos. So just to give you a quick roadmap of what I'm going to talk about today. First, I'm going to talk a little bit about ICE, or a lot about ICE. Oksana had said to be respectful, so I will do my best to be respectful when I'm talking about ICE. We will also be discussing the Fourth Amendment and how it plays out in public and private spaces. And then I hope to also give some of you guys just practical advice. You know, I have to speak sort of in general terms because I know that we are all the members of the audience are working in different sectors. But I hope to give enough practical advice that it's applicable to your different situations. The purpose of this, of course, is to help you think about how to continue serving your community in sort of a safe and smart way. You know, there's a lot of fear and uncertainty and chaos, as I said before, and I really think that this is intentional. But remember that we do have rights, and that the saying is true, that knowledge is power. So it's in our own interest and in the interest of those that we serve to invoke our rights when faced with oppressive tactics. Now, I also wanted to share this bit of advice taken from a graphic novel called The Hunger and the Dusk. This was written by Willow Wilson, who is the wife of a NERP colleague. And he shared this with me shortly after the recent elections. And I think it's good advice when sort of thinking about ICE and all the things that we have to face. The quote is, "You don't have to vanquish your enemies. All you have to do is outlast them." I've come back to this quote a few times when I felt frustrated, so I just hope it gives you some hope as well. So your role as a social service provider, I'm going to sort of do the boring thing here and just read the slide, but it's important. Nonprofit agencies and social service providers should protect their clients and staff to the greatest extent possible during an ICE interaction. Now, you can accomplish this by doing three key things. First, you should establish clear protocols for ICE interactions. These will be sort of the practical steps that all staff members should follow during the encounter. Secondly, you should assess and audit your workspaces and your event sites. Now, we'll be discussing how your protections can change depending on your location. So it'll be important after this to review your physical locations to know how to exercise your rights in the face of ICE interactions. And third, possibly most importantly, you have to train your staff. So even if you have clear protocols and well-demarcated work sites, if your staff is not informed of its rights and responsibilities, you place your staff and your clients at unnecessary risk. So this presentation is really just a starting point. And you guys are going to sort of have these action items to follow, and they should include these three steps. So stepping back a little, very quickly, ICE stands for Immigration Customs Enforcement. This is an agency of the Department of Homeland Security, and ICE is tasked with enforcing and maintaining immigration laws, similar to how police enforce and maintain criminal laws. Now, Malou mentioned this briefly about the new administration has rescinded some of the guidance on sensitive locations that you guys might be interested about. A very quick review: in previous administrations, there was guidance for ICE enforcement that basically discouraged them from taking enforcement actions around certain sensitive locations. Think about places like schools or hospitals, and where else? And courtrooms, for example. These are places where it sort of serves the public good for people to be going to these places and not fear going to it. If you are sick, we don't want you to pass on your illness to other people. We want you to go to a hospital and become better. If you are going to be a witness in a court proceeding, we want witnesses to come forward so that justice can be done. So previous guidance had said, ICE, please don't come to these sensitive locations because we don't want to create a climate of fear. But unfortunately, when this new administration began, Trump 2.0, we rescinded this. Instead of saying that there will be bright exercise their discretion, and I'm quoting here, with a healthy dose of common sense. Now, when I think about ICE, I usually don't think about anything that's healthy or anything that has common sense, but that's where we live with right now. So going back to the slide, what you'll see from the photos that while sometimes ICE agents will be in uniforms and clothing that identify themselves as ICE, you might also see things that say ERO or HSI, that stands for Enforcement Removal Operations or Homeland Security Investigations. They might even have clothing that only says police and doesn't say ICE at all, or even have just be in plain clothes. So I was actually hesitant whether I would actually show a picture or not. But please be aware that when ICE is conducting its operations, agents are often in tactical gear, sometimes heavily armed, and they may carry out their enforcement in large groups. So it almost feels like a militarized operation, and it can be very intimidating. So it's important to have this in the back of your mind to sort of consider this when preparing for an ICE encounter. But you should also remember that in the face of this, your clients and you have protections under the law.
You have to disconnect and reconnect them.
Yeah.
So what protections do we have? When talking about ICE encounters, we typically rely on the 4th Amendment to the Constitution, which protects us against unreasonable searches and seizures of people and property by the government, and the government here being ICE. Very importantly, this protects both citizens and non-citizens. So undocumented immigrants have this constitutional protection and can invoke their rights when encountering ICE. However, the extent to which a person is protected by the Fourth Amendment depends on the location of the search and seizure. So you'll recall earlier I mentioned about auditing or assessing your work or events sites. We'll see that there's a sort of distinction between public and private spaces and how your rights are affected where you are during an ICE encounter. Okay, so the important distinction in thinking about Fourth Amendment rights in ICE encounters is the private and public dichotomy. Okay, private areas are places where you have a reasonable expectation of privacy. The prototypical example here being your home. Your home is your castle, you expect to have privacy there. By contrast, public areas are those sort of areas where you don't have any expectation of privacy. So, out on the sidewalk or the street where anybody can go. Now, note that one way of thinking about the differences between public and private spaces is access. In your home or in certain areas of your work, you restrict access, staff only. However, access is typically not restricted at all on sidewalks or streets. Anybody can go there. You don't need anyone's permission to walk down the street. Okay, so given this distinction, the question becomes, what does ICE need to have to conduct a search or seizure in a private or a public space? So we'll see from sort of the boxes here that in a private space, ICE must have one of two things, either a proper judicial warrant or consent to enter a private area. By contrast, in areas, ICE must have a reasonable suspicion of an immigration violation to detain and arrest. Now, there is also an exception that I sort of put at the bottom there, and that's sort of the plain view exception. And these are sort of documents and information that's readily visible may be seized by ICE. So let's talk a little bit more about some of the details of this. So in the private setting, the general rule, again, is that for private locations, ICE needs either a judicial warrant or consent to enter and search. Now, with regards to consent, bearing in mind that we're trying to protect our clients and staff to the greatest extent possible, the simplest course of action, if just do not give them consent. Simply say, I do not give you permission to be here. Please leave. Now, I think it's a good idea for your organization to identify and delegate the authority to provide consent in these situations. For example, letting staff know that only supervisors or a director can provide consent to ICE to enter private areas of your workplace. Now, consent seems relatively straightforward, but you must be aware of ICE tactics to gain consent. ICE will use falsehoods, they will lie. And most likely they will also use a lot of pressure and intimidation. One person asking to enter, seems like it'd be pretty easy to say no. But if you have 15 people, 20 people screaming at you saying, let me through or I will arrest you, it becomes a little bit harder to stand up and say, no, I deny you entry. So training of your staff is critically important, and I would advise including role-playing components to sort of give your staff the tools to navigate these stressful situations. Okay, staying on private areas, I'm repeating myself, but the general rule is that ICE needs either consent or proper judicial warrant to enter and search private areas. Now, in all likelihood, ICE will not have a proper judicial warrant, which would allow them to enter and search your private areas. Instead, if anything, they will have what you see on the right, which is an administrative warrant issued by the Department of Homeland Security. I've X'd that out there. Now, there are telltale signs of an administrative DHS or Department of Homeland Security warrant. First, you will often see at the top of the page either letterhead or a seal even that says Department of Homeland Security. The second telltale sign is that it will have a title that probably says warrant for arrest of alien or warrant of removal / deportation. And the third telltale sign is that it is likely, and this is sort of at the bottom of the page there, signed by a low-level immigration officer and not a judge. Now, if you see these telltale signs, this administrative warrant itself does not allow ICE to enter private areas. So you can simply say, this is not a judicial warrant. I do not give permission to enter. Please leave. And ICE cannot lawfully enter. But how about valid judicial warrants? Now, again, it is highly unlikely that ICE will have this, but it's good to know. So to know whether you have a valid judicial warrant, there's 4 key items that I've sort of circled on that photo there to the left. First, it should be issued by a judicial court. You see I've circled there United States District Court at the top. And second, it should be signed by a judge or a magistrate judge. And that is circled at the sort of right-hand bottom side of that. And it should have the correct address for your location. It is the second circle from the top and sometimes in that dotted circle area as well. You know, ICE and law enforcement, they're known to get the wrong address. So make sure that it is the correct address. And finally, the last item to look for is this warrant executed within the time period specified in the warrant? This is the second from the bottom. And on this example, it's 14 days of the issue. So we would know that this is actually not valid because this was issued in November of 2013. But if they do have a valid warrant, you know, whenever you're presented with what they claim to be a warrant, you should inspect it and look for these signs, okay? Now, like I said, it is likely that they do not have a valid warrant, but you can always accept a warrant and still not consent to the areas that are not within the scope of the warrant. And if you are able to do this safely, it'd be nice also for you to have staff monitor ICE agents to make sure that they're adhering to the limits of the warrant. Like I said, in all likelihood, ICE will not have a proper judicial warrant, and so long as you do not give consent, they cannot lawfully enter and conduct a search of your private areas. Now moving on to public areas. Excuse me. The Fourth Amendment protections are not as strong relatively as in private areas, but protections do remain. So in public areas, and these are areas where anyone can access, including ICE agents, ICE needs what's called reasonable suspicion that an individual is in violation of immigration law to stop or detain them. Now, this cannot just be a hunch or based solely on one's perceived race or ethnicity. You know, racial profiling is illegal. Instead, an ICE officer's stop must be based on specified facts. Now, this is why invoking your right to remain silent is so important. If ICE has no information about you, they cannot lawfully stop and detain you unless you are the one providing them with the information that meets that reasonable suspicion standard. Now, based on our past experience, ICE typically does have
Hi, Henry. You are getting, you're frozen. It might be helpful if you stop your video.
Henry, can you hear us?
Since they have no information about these other individuals, they will
Henry,
try. Yep.
just for a second, you froze for all of us for about 1 to 2 minutes. So whatever you said in the last 2 minutes, if you don't mind repeating. Also, we suggest that maybe you turn off your camera. That might help with the quality.
Yeah, let me see if that helps.
Thank you.
Is that off? And are you hearing me better now?
For now, it's
okay.
better.
Okay, so I will see, I don't know where I last left off because I just talk a lot. But I think I was talking about, so as a quick review, in public areas, although the Fourth Amendment protections are not as strong as in private areas, you still do have Fourth Amendment protections. And specifically,
You got muted.
okay, I wonder if I have to do take 3 here. Apologies, folks. So Fourth Amendment protections not as strong in private areas. Sorry, in public areas, they are not as strong as in private areas, but you still do have Fourth Amendment protection. I'm gonna try to keep an eye on it to make sure I'm not muted again. But public areas, you know, the places where anybody can access, ICE can access as well. However, ICE needs reasonable suspicion that an individual is in violation of immigration law to stop or detain them. And this can't just be a hunch. ICE can't just arrest someone based on their race or ethnicity. Okay, instead, an ICE officer's stop must be based on specified facts, specific facts. And this is why invoking your right to remain silent is so important. If ICE has no information about you, they cannot lawfully stop and detain you unless you are the one providing them with the information that meets the reasonable suspicion standard. Based on our past experience, ICE typically does have specific targets in mind when they are going out for arrests. And they do have information about their targets, the name, photograph, and even legal status. But we know that ICE also casts a very large net and will often try to arrest other individuals around their targets. And these people are known as collateral arrests. But since ICE has no information about these other individuals, they will try to elicit information from them, enough information to detain and arrest them. So again, in these instances, invoking your right to remain silent is your best protection against this outcome. And also critically important here is your role. Since you are all service providers, you should be ensuring that your clients are aware of their rights and the importance of remaining silent during ICE questioning. Okay, so we're now all experts on the Fourth Amendment and how it applies to public and private areas. So let's think about our own work or your own work and event sites to think about how to best protect your clients while continuing to provide your services. Now, my understanding is that we have sort of an array of service providers here, so health, education, housing. I'm guessing that you provide your services in many different ways, you know, through workshops, at event spaces, in your own offices or schools or places of worship. And it is up to you to make an audit of these locations and to think critically about how you demarcate public and private areas. Now, if you'll recall, private areas are those where there is a reasonable expectation of privacy.
Henry, you're muted again.
Just got that up there. So I was talking about service providers making an audit of your locations to think about how you
Okay, muted again, and I know we're getting.
Yeah, I see that. Okay.
Okay.
Wow.
Can everybody please stop muting everybody? You can mute yourself, but don't hit mute all button, please. It's important because it mutes our presenters. Henry, also, we got a lot of questions related to what you're about to cover, so I'm just going to highlight that for you.
Okay, I'm hoping that I'll be able to finish sentences. I keep getting muted, I see. So I will, okay, I'll continue. So I did mention that it's up to you to make an audit of your own location to sort of delineate or demarcate your public and private areas. Now, if you'll remember, private areas are, am I muted again? Oh, sorry. Private areas are those areas where there's a reasonable expectation of privacy. Now, reasonable expectation of privacy is a legal term of art. Okay, that means that it has a very specific legal meaning and that's different from our ordinary thinking. But courts have explained that there are sort of two components to this. There's a subjective and an objective component. So just because you personally believe that an area is private, the reasonable expectation standard also asks, would society view this to be a private area? Now, this is the objective component. Okay, here's an example. I have a neighbor, I live in Seattle, right? And so I have a neighbor who, you know, none of us use our garages to park, but we often park on the street. You have a neighbor who insists that the parking spot in front of her is her spot and gets very upset when other people park there. She has a subjective understanding that that is her spot. But I think most of us would believe that, well, society does not view it that way, okay? So when you're thinking about delineating your public and private areas, you have to think about this objective component. And to meet this objective component for your private spaces, you might think about setting up things like signs. Think about your entrances. Do you keep your doors open or even locked? Or maybe do you have an intercom system that you can use to buzz people in? Now, at workshops or clinic events, you may also consider thinking about these reception areas that are separate from an event with closed doors. Here you're trying to delineate very clearly that one area is public and anybody can access, but this other area where we're providing services is a private area and it is only for staff and their clients. Now, when you're thinking about this, you also need to consider your own organization's mission and values. You know, I suspect that many of us here exist only to serve our community, you know, and we strive to be welcoming and accessible to our community members. So you'll need to sort of strike the right balance between safeguarding your clients, but also being accessible and welcoming to them. And also consider what information is in plain view. Recall that items that are readily visible can be seized by ICE. I have been in many events where, you know, organizations will have sort of a sign-in sheet that has everyone's name on it already and some information about where you should go. Well, ICE would probably be able to take that if it was in a public area because it is just in plain view, and you would be giving them some information for an arrest that they otherwise wouldn't have. Now, going down this list, you'll also want to, of course, have established protocols that are clear to staff and pay special attention to developing a communication plan that works for your organization. Remember, ICE likes to create chaos and fear. They like to move very fast. So you must be equally nimble in having immediate support to your reception or welcome desk areas. And as I said before, also important is training your staff on the protocols, particularly those that have first contact with clients and visitors. And I keep repeating myself, and I know I mentioned this before, but incorporating role playing into your training is typically recommended so that you create something akin to muscle memory that helps you in a real life stressful situation that you don't have to really think about it. You can just react because you've been trained to do so.
Henry, can I for a second?
Okay, so.
Henry, can you hear me?
Yep. I can hear you.
We received a number of questions related to what is or is not a private location. Can we address those right now before we go further? Okay, so we have specific examples such as food bank, a church, a lobby area at a clinic, and the restaurant. Would you want to address those?
Yeah, I can take a stab at it. I mean, I'll first say that one, I'm not an expert on Fourth Amendment, but two, there are gray areas, okay? And I think you will know your area best, but I will just take a stab at it. So the food banks that I have been to typically are open to the public. And oh, I see the chat. We have run a back. You have to have an intake appointment to read services. Would a sign and reception reads? So I would hope that a sign would be added. But since you, sorry, and this is in response to the food bank, it says that you have to have an intake appointment to receive services. This to me suggests that people come in at allotted times. So if you already have an appointment system, it seems like a good idea to also have closed doors. And that way, once the person is there for their appointment time, then you can open the doors to let them in. And where, sorry, Oksana, you said things like a church? Or was
Church, a restaurant, a library, and a public health clinic.
Well, okay, I'll try to respond generally. Maybe this isn't super helpful, but think about the access that you provide. If members of the public generally can come in there and walk freely around, it is probably a public area. So most restaurants, usually you can just walk freely in a lot of the areas. However, I also know that most restaurants usually have a door that says staff only, or commonly says that, and it's a closed door and only staff go back in and out of. And so that is sort of restricted to those members. I would, think that you would have a pretty good argument that that is absolutely a private area because are restricting access there. The same goes for, I guess, the libraries, because by and large, libraries are open to the public. So I would expect that ICE could, in fact, walk freely around a library, except that even in libraries, there are areas that are marked off, by closed doors. I know people have offices, and I would expect those to be private areas because I would view that to be private. I would know that I should not be going in there.
How about a church?
A church? Yeah, some churches are different, at least the churches that I've been to. So I would say by and large, churches are usually open to the public. The most churches that I've been to, usually the doors are open and they have, right into where the congregation can go and sit for services. There's an opening, anybody can come in and out of there. So by and large, I would think that that is a public area. But a church could take steps to change that. I also know that some churches have sort of a lobby area that is different from where they actually hold their services. And they could take certain steps to keep doors closed and to make it clear that one area is only for congregants and guests and the other area is only open to the public.
Okay, maybe last question. If there is an event that is happening, for example, outdoors, and it's by invitation, can they just use signage without having any walls around it?
Yeah, this is a tough one. I've thought about that myself, and I think that I would be a little bit concerned about open spaces because by and large, these are open to the public. You can try to cordon off or create tent areas that might give you some semblance of privacy, where you can say there's an expectation of privacy because we've sort of blocked view from other people. We've tried to maintain, separate space. But I don't have a great answer to that, honestly.
Okay, and sorry, I said that was the last one, but there is a recurring question about schools, K through 12, college campuses, and pre-K, preschools. Yeah,
okay, so I do have some guidance that, I think it's OSPI, the Superintendent of Public Instruction, last week released some guidance about protocols, and I've copied them at the back of this presentation, which I'm happy to share with all the attendees. I think in some ways schools can be ideal for creating safe environments. I say this because both of my children go to Seattle Public Schools, and the schools are already have a locked door policy, and you need to walk over, buzz in at an intercom where you're speaking, with reception, and you have to identify yourself before you're let in. So they almost are like tailor-made for safeguarding. Now, not all schools are like this, I know, but I think that if Seattle schools can do it, those policies, you can create other policies that will really safeguard your students and staff against ICE encounters. For colleges, honestly, I think if folks want to email or if email me generally, and I can do my best to talk to colleagues at the ACLU and other attorneys who are sort of in a better position to answer some of these questions. If you have a specific scenario in mind, I can give you our best guess for those. Okay, were there others, or should I continue?
I think maybe you should continue, and then we'll open it up to more Q&As.
Okay, thanks. I think we're actually pretty close to being finished here anyways. So if ICE comes to your workplace or event, hopefully you'll already have established certain protocols and trained your staff. But I really do think that you should certainly remember these items that I've listed here. Of course, be calm, but please be assertive. ICE may come in hot, but you should be confident in asserting your rights. You can ask for an ID. You should ask for a warrant, and staff should also know who to call for immediate support. You need to safeguard your workspace. Staff and clients. Do not give consent to enter private areas. Also, don't share information about your staff or clients. If ICE asks you questions, exercise your right to remain silent and politely ask ICE to leave if they're interfering with your services. Now, you should also inform your clients and staff about their right to remain silent, but please be careful not to direct people not to speak with agents during an ICE encounter. Okay, you do not want to be liable to or risk interfering with ICE activities. Okay, but I think you are well within your rights to simply inform your clients and staff about their right to remain silent. You should not, of course, lie. You should not hide your clients, and you should not assist your clients in fleeing or trying to escape. And during an ICE encounter, I do encourage you to contact WISN. WISN is an acronym for the Washington Immigrant Solidarity Network, and they can provide support through the rapid response teams. I've included the phone number there. I hope that everyone here saves that on their phones right now, frankly. Now, although you don't want to, hide your clients or aid in their escape, you do have the right to carry on with your ordinary course of business without interference from ICE. So, if in the ordinary course of your services, you need to move your client from a public space to a private space, for example, from the reception to your own office, I would encourage you to do so. Now, if ICE interferes, I suggest simply asking, am I free to conduct my business and serve my clients? Okay, certainly if ICE says no, you do not want to escalate the situation, but I think that you should take steps to see whether you can create a safer environment for your clients. And finally, please document your ICE encounters. I suggest writing down notes, either as the encounter is happening or immediately after. And if possible, and this depends on your read of the situation, you can try to video the encounter. However, I suggest announcing that you are recording. You do not want to take any actions that could be construed as threatening to ICE, such as them accusing you of reaching for a weapon. So this will definitely require your own judgment of the situation. But if you do decide to record, I would announce it aloud that you are doing so. Okay, moving on to documenting ICE encounters, or talking a little bit more specifics, I'd like to actually read a recent description of what we received 4 days ago, reporting on an ICE raid on a supermarket. So approximately 15 heavily armed ICE officers, identified as DHS, HSI, with ICE removed from the arms of their jackets, entered the supermarket without showing any warrants, judicial or otherwise. They walked directly into a designated staff-only area, screaming at everyone as per their MO. They ordered employees to line up against the wall and demanded identification. 3 of the men who complied were subsequently arrested. Okay, so now it's not clear whether anyone there asked if they were free to leave, but it does seem sort of obvious that ICE broke the law in making this arrest. And I'm sharing this description not to frighten you, but to give you a sense of what to expect. Namely that ICE will push the boundaries of the law, and they may even overtly break it. So even if you follow all the guidance that we've discussed here today, even if you've looked through the resources that I'll be sharing with you, there is still a possibility that ICE will simply disregard the Constitution and make arrests in an unlawful manner. So here is where documentation becomes really important, just an important tool in fighting back against these unlawful actions. If attorneys have reliable evidence, such as video or contemporaneous notes, we can use this evidence to fight back against unlawful actions in court, and of course deter ICE from acting unlawfully in the future. And the documentation is important not only in your own workplace, but also if you witness ICE interactions with community members out on the street or in the public. So I've put down some important points that I think in this slide here, including recording the name, if possible, the name, badge number, contact information for the agents, and asking for a copy or to take pictures of any cards, warrants, or documents that they presented. Please note the date and time, the number of agents, and all communications and ICE actions to the best of your ability. If safe, announce that you will video record the encounter and do so. Now, sorry, I mentioned contemporaneous notes. What I mean by that is if you can take notes as the event is occurring or shortly thereafter, those will typically be pretty reliable in a court of law. So it's nice to, if you can record this immediately as it's happening or soon thereafter. But please do maintain a safe distance. You have to exercise your judgment here, and you don't want to escalate what's already happening. But if possible, because ICE does often work in groups, if you have enough staff, it would be great if you could accompany each agent to know what they're doing in your workspace. And once again, I've included the contact information for Wizen that I think that if it's either happening in your workplace or even out in public, you should let them know. Okay. Finally, I mentioned action items before, and I will mention it again. I hope that attending this presentation is just a first step for your organization, and that you complete the following action items in the coming days and weeks. First, I hope that you are able to review some of the resources and materials from this presentation. Oksana is sharing many with you. And on my last slide, right here, I will have links as well that I hope will be helpful. Your organization should also establish protocols for interacting with ICE. And these protocols should be obviously clear and easy to understand. You should audit your workspaces, as we discussed before, and your event sites, thinking about how best to protect your clients and staff. And of course, train your staff, particularly reception, or those that first greet visitors for ICE interactions, and to inform clients of their rights. And finally, most importantly, please continue to serve your community, right? We do not want to push our community members into the shadows. We want to create safe spaces where all immigrants feel welcome and supported. Thanks, everyone. Oksana, are there more questions?
Yes, we have many more questions and we still have half an hour. So please continue submitting your questions, but be patient with us as we're going through them. I see several questions related to the definition of sanctuary city, what it means and what it doesn't mean. Somebody was asking that they're confused how ICE can do arrests in Seattle or in Washington as we are sanctuary city and state. So I just want to emphasize it very clearly to not give a false sort of hope that any immigrant is safe from ICE detention or arrest in our state or the city. Sanctuary does not mean that ICE cannot come here. That's their job. They enforce immigration law all throughout the United States. What I mentioned at the beginning of my presentation is immigration is solely federal jurisdiction and law. So that means they can enforce it anywhere in the United States, including in Seattle. What welcoming or sometimes sanctuary terms mean, they're not defined in law. They are sort of terms of art too. They are referred to as welcoming or sanctuary. What they mean is that local resources are not used to help ICE conduct their operations, that our police doesn't cooperate with ICE, but they still have all the tools that they need to conduct those. So I just want to make sure that that is clear and that immigrants that might be targeted by ICE can be targeted here anywhere in the state. There is a couple more questions, Henry. I'm going to read them to you or summarize them to you. There are a lot of questions about consent to enter private or public space in an organization. Sorry, somebody's not muted.
I think it's the one I did. No, I did that one this morning.
If you can all mute yourself again. Okay. Who can give a consent to enter? Does it have to be a supervisor, or does a position of the person who works in the organization matter? Also, there's a question about can you not give consent if ICE has a judicial warrant? Let's start with those.
Sure. So on the consent question, yes, anybody can give consent to ICE to come in, and if ICE comes in and somebody from your staff says, yes, please, let me show you around, they can come in. So this is where my suggestion of training your staff to know to not give consent and to deny entry is important. Now, I think this question I'm seeing from Grace is reception telling ICE that they don't consent enough? Yes, Grace, that is enough. And that should be enough. Does it have to be a supervisor? No, it does not. Now, when I'm talking about a supervisor, I did make the suggestion that you delegate authority to an individual or group of a certain number of people as the only people who might be able to consent, who might be able to allow ICE to come in. Okay, everybody else, if they are asked, should say, no, I do not give you permission, and the only person who has permission, who has authority to give permission is my supervisor, or the director of this office. And so they should then funnel the questions to those people who have that authority. Okay. And sorry, what was the second one that was similar?
Can you deny access to a non-public space if they have judicial warrant? Okay,
if they have a valid judicial warrant, you do have to comply with the judicial warrant. Okay, and that applies to a private space. So just like you've seen in the movies where they say they come to your home and somebody says, well, do you have a warrant? And they say, yes, I do. Well, then in fact, they can go into your home with that valid judicial, and that is a private space that they're entering, so long as that judicial warrant is valid.
Can you show the slide with the links? A few of us have asked this and nobody's answering that.
Yes, absolutely. I will be sharing these slides, and the links they'll be whatever hyperlinked, I guess. So you can just click on them.
Okay, so we have a number of questions related to the treatment of minors at schools. Can children be arrested and detained by ICE? Can ICE come on public school playgrounds?
So I'm gonna defer this to the guidance that I've attached on here. I have not thought about those specific situations, but by and large, my understanding is that they do not allow permission for ICE to enter any public school property, and that all questions on that should be directed to, I think, the guidance, the principal or someone else within, or the superintendent of the system.
Thank you. Now about interventions while observing an ICE arrest. So how aggressively can community intervene? Can they videotape, and can they be arrested for obstructing?
Yes, you can be arrested for obstructing if you are in fact obstructing. This is why I suggest that you have to sort of exercise your judgment in the situation. I do encourage you to document in some way what is happening. Now, whether you can do it safely by recording, it depends on the situation. You know, if you happen to be right next to a person who is the target of arrest and you immediately reach into your pocket for your phone, I would be concerned that ICE would be interpreting that as you reaching for a weapon, and you would place both yourself and the target of the arrest, the community member, at risk. And I would absolutely not want you to do that. So my advice is to stay within a safe distance, and to, if you can, announce that you're recording if you feel safe in doing so, and to go ahead and record. I do think that, you know, on the intervention side, the intervention sounds too much like you might be interfering with their enforcement activities, and that would put you and that person and the other community member at risk. But I do think that you could inform in a reasonable manner people about their rights, including their rights to remain silent, so long as you're doing it from a safe space and not interfering with the ICE enforcement.
Thank you. We have a couple of questions about what documents would you recommend community members to carry on them? Should they be carrying them, like Social Security or passport or birth certificates at all times? And what about people who have expired immigration status? Are they at risk of detention or deportation?
Okay, this is a really good question and a really tough question, and the answer I'm going to give to you is sort of unfortunate, which is, or really wishy-washy, which is it depends on the situation. If you're asking me for what is a safe document for everyone to carry, it would be one of those red cards that says know your rights, and that contains the rights, including the right to remain silent. I say this because everyone's immigration situation is slightly different, and their own capabilities are slightly different as well. So what they would really need to do is speak with an immigration attorney to have an understanding exactly of what their status might be, what their immigration history is, in order for them to give you advice on what sort of things they might carry that would protect them from an arrest or detention. But the only generalized advice I can give that I think is pretty much applicable to everyone would be those know your rights cards, red cards that talk about your Fourth Amendment rights and encourage you not to answer questions, but to ask for an attorney.
Thank you. We have 2 hands up for, I assume, people who cannot use the chat. So how about, let me check. Who's first? Patricia, can you unmute yourself, please? Hello, Patricia. Do you still have a question?
Yes, I do. Can you hear me now?
Yes.
So, Henry, I'm with the Jefferson County Food Bank Association. I'm over on the Olympic Peninsula, and you kind of cut out around some of the conversations about food banks. And, we are self-declaration. So folks that are coming to us have self-declared that they qualify for our services. And at our food banks, we have an intake coordinator who literally checks the clients or the customers in as they come through the food bank. Can you, I feel like I need to reach out to them, but again, just for clarification, is a food bank necessarily a public space, or would you consider it more a private space, like you're coming to a food bank for services? Thank you.
Hi, Patricia. Yeah, I think the food bank is in a position like a lot of other places that you are going to have both public and private spaces there. And based on what you told me, it sort of sounds like you could have an area, that's separate from where your food is located, that is a reception area. And that there's a wall between them with a door that's ordinarily closed, since your coordinator makes appointments with each of these people coming in, each of these clients. So if you were to do something like that, then I think that you could have pretty good arguments that reception area is public and people can come and learn about the food bank there. But in order to go into your private area, they have to have an appointment with your coordinator. And that private area, you might think about having doors that are closed at all times, and that there's signage that says, staff only, please see, your coordinator if you require entry.
Can't unmute myself. Can you unmute yourself? Oh, okay. We have another question. Jorge or George Garcia next, please.
Good afternoon, Henry. My name is Jorge. I work for Employment Security Department for the Division of Agricultural and Seasonal Workforce Services. All H-2A workers come to work in agriculture with temporary visas in our program. So what is the guidance if these H-2A workers are encountered by ICE and the public?
Hi, Jorge. For specific advice like that, we would need to discuss this offline, okay? But I will ask that Oksana share my email, and I can do my best to answer your question, okay?
Thank you.
And can I just jump in that we, everyone should know their rights, right? And so the Know Your Rights information still applies, whether the temporary H-2A status or else. I think that also helps, but they should not necessarily be impacted because they would not be necessarily subjected to the expedited removal. But as Henry said, it is on a case-by-case basis, so it would be good to learn more.
Okay, next question, Catherine, please.
Hi, Henry. My name is Kat Roberts, and I work at a public health clinic over in Bellevue. And we work in a space that's owned by King County and federally funded. Can we determine the areas that are restricted? And does HIPAA protect our patients at all?
First, yes, HIPAA should protect your patients. Now, just because you're federally funded, I guess it would be hard for me to answer your question without knowing more about the agreements that you have with the government on that space. I say this because there are some places that the federal government regulates completely. I didn't discuss today anything about border areas or ports of entry, because there are some places, for example, in airports that the federal government controls completely. But there are other parts of the airport where they'll allow the state authorities to run areas. And I just don't know enough about your particular situation to have sort of any meaningful advice. So apologies.
Thank you.
Do you just want to mute it, or do you want to?
And ask for next person. Mine is frozen.
What's your question?
So I'm not hearing a question, but I do want to say one thing, about this. I think about this gray area, right, of the public-private demarcation. One thing to remember, though, is that you still have Fourth Amendment rights, regardless of whether you're in a public area or a private area, right? And from that example that I gave to you, or that description I shared with you, there's a good chance that ICE might not follow the rules anyways, right? No matter how well you've demarcated your areas or how obvious that it is a private area they should not be going into. So it's, even though I do encourage you to take all the steps, that you can think of to demarcate these areas, sometimes it is equally important to document well what they're doing, so that we can try to prevent these sorts of things in the future.
All right, Hannah, the dishwasher, you're up next for your question. Go ahead and unmute.
Hi, thank you so much. This has been really helpful. I just had two questions. One was, what grocery store did they go to? Like what area? I'm curious. And then the second question is, say they come with say they think that I'm with Hunger Intervention Program and we have several meal sites. Say they come with an arrest warrant or the search warrant with the person's name and address. So they have the right to go to their public address, but they're at our site, which is a different address. Can we deny them access based on?
I don't say anything. Yeah, you don't say anything.
The address not
no
matching? Where they're at?
Someone was over talking. I'm sorry about that.
Oh, okay. So yeah, what grocery store do they go to? Like, I'm just wondering, like, are they just going to majority brown people shopping places and then just, I don't know, like, or if they're just going to find employees. And then second question was, if the address on their warrant does not match the location, like say we have a client at our meal site, but then their warrant has the client's home address. Can we just say, nope, you don't have the right address on here, bye?
Henry, did you hear those questions? Hello? Henry might have some technical difficulty, so I cannot speak as to which supermarkets or stores they've been going to. Henry, can you hear us now?
Hear me?
Yeah.
Are you able to hear me?
Yes. Can you address the question about the
Okay.
warrant being for a different location?
Yes. Well, I'm happy to answer both. I mean, the first one, I didn't mean to use that to create more fear about, for our food service providers. That was just an example that happened out in New Jersey at a grocery store. Now, on the second question, you're saying that they have I will assume a judicial warrant that is otherwise seems all correct, except that the address is on a different area. So in that instance, I would say that it is not, because they are at the wrong place. They are authorized to search that address that they have on there, but not just because they have information warrant doesn't mean that they can go anywhere, right, to search for this person. So it has to be at the correct address on that otherwise valid judicial warrant.
Thank you.
Thanks
Right,
very much.
Delaney?
Hi, my name is Delaney. I'm a resident services coordinator for Mercy Housing. Many of our residents who have expressed fear about these situations are non-English speaking. And so my main concern is that, if ICE were to arrive at their private residence, how to encourage our residents on asking for proper translation services, just to make sure that a situation isn't being taken advantage of for that reason.
Yeah, thanks, Delaney. That's a great question. I appreciate your concern in that situation. When you are asserting your Fourth Amendment rights, you can do so in any language, okay? So there's two answers that I have for you. First, they should say it they should assert their rights in the language that they are most comfortable with. The second thing is I just learned about a handy new app. It's unfortunately only available on the iPhone right now, but they're going to have it ready for the Android, that does have know your rights in several different languages, and also has sort of many cool features, such as saying out loud that they are exercising their right to remain silent. The app also has an automatic messaging system that alerts their trusted friends and other people that they are being stopped and detained by ICE. And again, this is I'll have a link to this and it will be shared on the last page of this presentation. So thanks, Delaney.
Okay, we have Angela next. Angela, if you still have a question, please unmute yourself.
Yes, thank you so much. Can you hear me?
Yes.
Yes. So I do work for a nonprofit organization providing integration support to refugees, immigrants, and asylum. So as such, we also have ESL classes, and we have people that were housing in hotels. So my concern is just about the places and how it's treated. So is a place like a nonprofit organization location considered a public place where ICE can just walk in? And also the other concern is about the hotels where we're housing people. I was kind of looking forward to this so that we can also know what to tell the hotel owners about how to behave themselves if ICE was to show up, and also for the people staying at those places, how is it that they should conduct themselves during an ICE search or whatever.
Yeah, thanks, Angela. First, I will, I feel like I'm a bad record here, but I do have some resources specific to shelters and housing that are included on my the last slide that I have that I'll be sharing, and I hope you take a look at those to give you a better sense. And it's hard to answer the question about the public and private without knowing the specific details of those areas, particularly in your nonprofit organization. But one question to ask or one idea to think about, as I mentioned before, is that idea of access, right? Is this an area where ordinarily any member of the public can sort of walk freely in? If that's the case, then it is probably a public area. And I don't know how exactly your nonprofit is situated, But my guess is you probably also do have private areas in there. I imagine that most of us do have different rooms because we want some confidentiality and we want our clients to feel safe and not have to share everything with other people. So those areas, would probably be considered private areas because that access again is restricted in those areas.
Can you see that box right there, man? That's garbage. The tissue.
John Grant, please.
Hi, John Grant with with Lehigh. A really basic question, and you may have already covered it. If like we have apartment buildings, and if there is a front door to the property that you can't see through, it's like a solid door, and ICE is on the other side, and they say that they have a valid warrant, how can you check to see that the warrant is valid without opening the door? Because doesn't opening the door invite them to then kind of push their way through and have claim, that they have consent to enter? So what do you do in that situation? How can you get your eyes on that warrant without opening the door?
Hey, John, haven't seen you in a while. Is there a space at the bottom of that door that they could slip the warrant through? That's what I would ask.
No.
Okay. So are there any other ways that you can reach ICE that is not that, that is a different entrance?
It depends on the property.
Okay, so I think this is where you might want to think about your protocols, right? So I think that it's great that you have a closed door, right? And that you're restricting access there. And there are different ways that you could get around this. One obvious one seems to be, installing a simple camera where you can ask them to place it in front of it, and you can then, inspect it yourself. Another way is if you have other entrances where you have staff that know to go there and to try to, meet with ICE, because in a public area, where they can then ask for their identification, ask for a warrant, and they can then physically inspect it themselves right there. But it sounds like it'll depend on your different, your different properties.
Yeah, I think what we'll do is have people exit the back entrance, walk around the building, and just talk to the ICE officer outside.
Yeah, and but do be aware, one thing, I don't want to scare people, but it is not uncommon for ICE to surveil areas first before they actually, go to make arrests. They'll often try to see if somebody is there and comes often, and it might be the case that they have, officers at multiple entrances. But I still think that you can have protocols, with other entrances going out and closing it immediately, that will safeguard the clients in this situation. And I should also say that, if you open the door, ICE still does not have permission to just barge in unless you provide them either consent or they have a proper judicial warrant. Now, I'm not saying that that won't happen, but they should not be able to just barge in at that moment. And if they do, if for some reason, your staff does in fact open the door to take a look at the warrant, you can accept that warrant and you can still say, I do not give you permission. And as they are walking through the property after inspection of the warrant, you realizing it is not valid, you can continue to say, this is not a valid warrant, and I don't give you consent, please leave, and document that you have done that.
Thank you, Henry. It's 4:01, and we are unfortunately at time. I understand many of you had your questions not answered, and we still have people with raised hands, and unfortunately, we will not be able to get to you. So we are just extremely grateful for all of you showing up today, asking your questions, and being concerned for the communities you serve. we will do our best to share all these resources on our website. I believe in the chat we posted the link to our website, which is Seattle Office of Immigrant and Refugee Affairs. In the coming days, we will share the recording, the slides, and other resources shared in today's meeting on that website. Henry, I did not post your email address in the chat because I wasn't sure if you wanted it available to 1,000 people or not. But for those of you who are interested in getting any of NERP's staff email, they're all publicly available on their website. So I would say you can find it there without me creating a lot of emails for Henry or Malu. We really appreciate your questions, your thoughtful approaches, but as you've learned today, a lot of what was shared is not a clear cut, and the answer might be it depends. It depends if your area is public or private, so there is more work that you might need to do within your organization yourself. Highly encourage you to visit Northwest Immigrants' Rights Project website for all the resources shared today. They're all available on their website already, but also come to our website in the coming days and we'll share it there. If you have any questions and want to reach out to us, all of our staff emails are also available on our website. Do so. We encourage partnerships in the future as this year's promising to be quite hectic and demanding of all of us. Apologies for all the technical difficulties. We really did not foresee us hosting 1,000 plus people on the call. So next time we'll try to accommodate this large of a group, maybe in a different setting. So really apologize for everything that we had to deal with in terms of tech today. And with that, thank you so much. And this is not the last time we convene. I'm sure we'll have other informational sessions and hope to meet with you in the coming year several more times. Thank you and have a good day.
Thank you. Bye.
Thank you so much. Thank you.
Hi, Hannah. It's Andrea.
Did you say that you have more than one?
Hi? Does someone know me?
Hi, Oksana. I have a question for you. Did you say that you had more than 1,000 people attending your session today?
Yeah.
Oh my goodness. Okay, wow, that's amazing. Okay, thank you very much. I will look forward for the recording.
They don't let me
Thank
enter
you.
after 1 hour, so I don't get all of it. So can we do it next time the setting is different? Because that's half of it I don't understand what's happened.